Welcome to this module of the Library Laws course, part of the State Library of Iowa Endorsement Program. This module is an overview of Iowa's open meetings and open records laws. My name is Mary Ann Morey. I'm consultant for the Central District of the State Library of Iowa.
And I'm Mandy Easter, law librarian with the State Law Library of Iowa and state library consultant.
At the completion of this module, you should be able to identify where to find information about Iowa Code Chapters 21 and 22, be able to locate answers to FAQs regarding these laws, and relate the laws to common library board scenarios. Before we get too far into our class, let us briefly define what we're talking about when we say Iowa Code Chapters 21 and 22.
These chapters provide a framework for managing business by public agencies. The laws also provide a mechanism for an aggrieved citizen who believes a governmental agency has improperly denied access to a meeting or a record. Iowa law assumes that meetings and records are open. Iowans do not have to make a case to attend a governmental meeting or to see a public record. To the contrary, meetings must be open and records must be available for inspection unless the case for closure is specified in law. The Iowa Supreme Court has been adamant on this point, noting that most records are open to public inspection, even though such examinations may cause inconvenience or embarrassment to public officials or others. Iowa laws provide a general approach, that of assumed openness, and establish guidelines regarding when a meeting can be, not must be, closed, and what records are confidential. The laws provide a framework to help reasonable people ensure that public business is conducted in the public eye. Unfortunately, citizens and the news media do not faithfully attend meetings of public agencies. Meeting just by themselves, public officials may lapse into informal ways of handling business, a habit that will ill serve them when major or controversial issues put them in the spotlight. It is likely better to adhere to open meeting legal protocols at all times, so that when difficult issues arise, the focus can be on the issues and not on what procedures must be followed. Both chapters provide remedies for citizens who successfully sue a government agency for holding an illegal meeting or denying access to a record that should be open for public inspection. While providing such clout to citizens, however, the laws also provide ample protection for public officials who rely upon legal advice in interpreting finer points of the law. It's a good balance. For purposes of our class, we will define open records as what's on the slide, but understand that many more kinds of documents are involved when complying fully with open records laws.
These laws are often referred to as sunshine laws, and all states have them. Let's begin our first learning objective. Identify where to find information about these laws.
One of the best places to access information about any Iowa law is from the Iowa Legislature's website. From the home page, go to the search box labeled Iowa Code Quick Search and type in the chapter and/or section number for any Iowa law. For example, 21, the chapter pertaining to open meetings. Click the Go button to the right of the search box, and the entire chapter will pop up with a toolbar that allows you to print it or manipulate it in several other ways. You can even access other laws referenced in the content by clicking on the blue links.
Another place to get information about chapters 21 and 22 is the Iowa Freedom of Information Council's website. There's a nice little handbook on this topic available there. You can see the URL noted on the slide or do an online search for the Iowa Freedom of Information Council. Let's look now at our second learning objective, locating answers to frequently asked questions about these two statutes.
One of the most important organizations you can contact regarding questions pertaining to open meetings and open records is the Iowa Public Information Board, or IPIB. IPIB is an independent agency governed by a 9-member board appointed by the governor and confirmed by the Senate. Again, quoting from IPIB's website, IPIB is a one-stop destination to answer your questions or address your concerns regarding chapters 21 and 22, Iowa's open meetings and public records laws.
Another place to get answers to questions about chapters 21 and 22 is in the State Library's Trustees Handbook. You can access the handbook from the State Library's website. Your library is located in one of these districts of the state library. Each of the 6 districts has its own degreed librarian serving as a consultant. Those of us who are district consultants can assist you with questions, direct you to information, and provide you, your staff, your library board, and even your city leaders with information about how open meetings and open records laws apply to your library board. Simply contact us.
The State Law Library is available to assist with any legal information you may need pertaining to Iowa Code Chapters 21 and 22.
Mandy has done a phenomenal job of providing a variety of legal FAQs that she has prepared and posted on our website. Simply follow the breadcrumb trail on this slide. Click on the blue Link to Online Searchable Database to find information that will answer a variety of your legal questions. From the Library Law FAQ page, choose the FAQs Search Page tab in the upper left-hand portion of the page, and that will take you to this page. Once here, you can sort the fields. For instance, you can click Topic and see all the questions that pertain to the topic of, say, human resources and labor. Click the far right side View option to see the full response to the question, which you can easily print or from which you can copy the URL and share with others, such as your trustees. Here's an example of a view for the question pertaining to open meetings laws and job interviews.
The Iowa League of Cities has lots of good information available on its website. You simply have to go through a free and very brief registration procedure to be able to log into its member resources pages. The organization counsels, guides, and trains city officials on how to effectively, efficiently, and legally run a city. The League staff can also provide valuable backup for library directors and trustees when there are conflicts with city officials regarding library-related law. Finally, your city attorney can provide library directors and trustees with legal advice. Be aware that in most cities, agencies that use the city attorney's services will be charged an hourly fee of some type. In other municipalities, agencies cannot contact the city attorney without prior approval from the city administrator. In some cities, mainly larger ones, there are few, if any, restrictions on contacting the city attorney's office. Check with your city to learn the proper procedure for contacting the city attorney and ask about any agency fees for obtaining legal advice.
Yet another way to get answers to your questions about chapters 21 and 22 is by attending training sessions on the subject matter provided by the State Library and the Iowa League of Cities, as well as other organizations. Before we move on to our third and final learning objective, let's briefly take a look at chapters 21 and 22 so you know what they say and what they mean for your library. Iowa Code Chapter 21 is the Open Meetings Law. The purpose of the Open Meetings Law is to make sure that the government doesn't conduct its business in secret and that its work is easily accessible to the people. Iowa's Supreme Court justices wrote, quote, "The legislature clearly intended that public bodies subject to the Open Meetings Law deliberate the basis and rationale for important decisions as well as the decisions themselves during open meetings," end quote. Because the library trustees are duly appointed to a city board, library directors and trustees must ensure that their meetings and the information about those meetings are all easily accessible to the people. Chapter 22 of Iowa Code contains the state's open records or public records law. This is the statute that defines a public record.
Part of the Open Records Law affirms the right of every person to examine public records. It also says, unless otherwise provided for by law, the right to examine a public record shall include the right to examine a public record without charge while the public record is in the physical possession of the custodian of the public record. It's very important to note that for Iowa's public libraries, the custodians of their records are the directors, not the boards of trustees. Public records would include library board minutes, director reports to the board, and library budget reports, among other records.
Our final learning objective for this class is to relate Iowa Code chapters 21 and 22 to common library board scenarios. We have a few such scenarios to share with you based upon actual comments, questions, and situations we field at the State Library. Here's number 1. We're just a small town. Those laws are for bigger cities and don't apply to us. We hear this comment a lot at the State Library. My response is always, and we have state laws against murder and theft. Do you think those laws don't apply in your town too? Chapters 21 and 22 are laws of the state, and they apply to all governmental bodies, including library boards of small towns.
The law does not exempt small towns or any other kinds of cities from our sunshine laws. The citizens of the smallest town in the state are assured the same level of access to the transparent operation of their municipalities as the citizens of Des Moines, Davenport, Cedar Rapids, or Sioux City. Equal protection under the law is a constitutional right. Iowa Code Section 21.6, entitled Enforcement, allows suits to enforce the open meetings laws to be brought in the district courts. Once a party has demonstrated to the court that the governmental body is subject to the open meetings laws, the burden is on the governmental body to prove that it did not violate the law. If a board cannot adequately defend itself, the court will assess each member of the board who participated in the violation $100 to $500, plus all court costs and plaintiff's attorney fees, and the court will void any action taken while the law was being violated. The law specifically says, ignorance of the legal requirements of this chapter shall be no defense to an enforcement proceeding. If in doubt, it is the governmental body's responsibility to ascertain the propriety of any action or to seek a formal opinion of the body's attorney. Same thing for Chapter 22, which says that it's illegal for any person to deny or refuse a citizen of Iowa any right under this chapter, or to cause such a right to be denied or refused. Any person violating or attempting to violate a provision of this chapter shall be guilty of a misdemeanor. We can assure you that both IPIB and the courts have ruled against non-compliant library boards in the past, and they can do it again. Iowa Code Section 21.2 is entitled Definitions, and I would encourage everyone to take a look at the words and meanings used with respect to these laws. The types of governmental bodies to whom the law applies include, quote, a board created by the statutes of this state. And how do we know that this means a library board? We know because of Iowa Code Section 392.5, which is the code that authorizes a library board to be established by an ordinance adopted by the City Council. Library boards are boards created by the statutes of this state, so they are subject to the laws in chapters 21 and 22. We do want to clarify that private nonprofit organizations such as Friends of the Library groups, library foundations, and county library associations are not subject to open meetings laws, and the same goes for meetings involving library staff, whether those meetings are with other staff members or with people outside the library.
Oftentimes, trustees just want to get together to learn more about a topic or to talk about an issue. Sometimes trustees will refer to these gatherings as work sessions. Is there a difference between a meeting and a work session? And is it okay for trustees to get together just to talk about the library?
The law defines a meeting as a gathering in person or by electronic means, formal or informal, of a majority of the members of a governmental body where there is deliberation or action upon any matter within the scope of the governmental body's policy-making duties. Meetings do not include a gathering of members of a governmental body for purely ministerial, which means educational or informational, or social purposes, where there is no discussion of policy or no intent to avoid the purposes of Chapter 21. In 1981, an opinion of the Iowa Attorney General noted, quote, the nature of any such gathering may change if either deliberation or action occurs. A meeting may develop if a majority of the members of a body engage in any discussion that focuses at all concretely on matters over which they may exercise judgment or discretion, unquote. Unfortunately, we sometimes hear about trustees who appear to be circumventing the law by practicing serial and successive private communications in which one or two board members attempt to survey the other trustees or achieve some sort of consensus ahead of a regular meeting by talking with fewer than a quorum, either in person, by phone, or by email. This is called a walking quorum. The IPIB refers to the phenomenon pejoratively as shuttle diplomacy that doesn't comply with the spirit of the law. The Iowa Supreme Court ruled against a County Board of Supervisors walking quorum. In the Supreme Court's decision, the justices wrote that walking quorums, quote, would clearly be at odds with the intended scope and purpose of our open meetings law, which is designed to ensure the government doesn't do business in secret. The strategy of the defendant limited public controversy, allowing them to reach compromises and implement the plan without deliberating a single detail in public. The legislature clearly intended public bodies subject to the open meetings law to deliberate the basis and rationale for important decisions such as these, as well as the decisions themselves during open meetings. So to answer Marianne's question, yes, there are differences between meetings and mere work sessions, and no, trustees may not informally gather to talk about the library. Anytime a majority of your trustees gather to deliberate or take action on library matters, it's a meeting. If you didn't properly notice the public and post an agenda, it was an illegal meeting.
We occasionally, likely more than we care to count, hear from libraries that say they don't let the public know about a library board meeting because the board doesn't want the public to hear the conversation. This is sometimes true of library boards conducting an evaluation of the library director.
First of all, director evaluation should be conducted during open board meetings, but the law provides a method for closing that specific part of the meeting under certain narrow circumstances. Iowa Code Section 21.5 is entitled Closed Session, and subsection 1I allows a meeting to be closed, quote, to evaluate the professional competency of an individual whose appointment, hiring, performance, or discharge is being considered when necessary to prevent needless and irreparable injury to that individual's reputation, and that individual requests a closed session, unquote. The key clauses here are that the director is led to believe the evaluation is going to be bad enough to needlessly and irreparably damage her reputation, and she requests that the board close that portion of the meeting. The request should be in writing ahead of the meeting if possible. The board cannot go into closed session to discuss disciplining or firing the director on its own. The director must request it. Once the board has voted to close the meeting, the director can be asked to leave. He or she does not have a right to be present during the closed discussion. Furthermore, the board is prohibited from taking any final action in closed session. All voting must occur in open session. The law details the extensive record keeping that must be done during a closed session. Notes must be taken, the entire discussion must be tape recorded, and the notes and tape must be stored in confidence for at least a year, usually in the city's vault. No one, including the director, can access the notes or the tape. Only certain state agencies and the courts may do so after a complaint or suit has been filed. There also tends to be confusion about closing meetings to discuss general personnel matters. It is inappropriate to close a meeting to discuss things like director or staff wages, salaries, benefits, working conditions, or even laying off or reassigning staff or eliminating certain positions. These difficult discussions should all be held during open meetings.
A primary purpose of the open meetings law, which we saw in a previous slide, is to ensure that these meetings are easily accessible to the people. Deliberately not telling the public about a library board meeting is a direct and flagrant violation of Iowa Code Chapter 21. Section 21.4 clearly states in subsections 1 and 2 that a governmental body shall give notice of the time, date, and place of each meeting and its tentative agenda to apprise the public of that information. And notice conforming with all of the requirements aforementioned shall be given at least 24 hours prior to the commencement of any meeting of a governmental body. In 1999, the Iowa Supreme Court revisited the issue of what constitutes an adequate agenda for a public meeting. The court ruled that closed sessions of meetings subject to the open meetings law must not include issues not listed on the agenda. An agenda for a public meeting must specifically state any issues the board intends to discuss in closed session, and discussing topics not noted on the agenda violates the law, even if the public could have anticipated the issues would arise. If someone attending a board meeting raises an issue not already on the agenda, The Iowa League of Cities and the State Library advises board presidents to acknowledge the comment and assure the person that the board will consider discussing the issue at a future meeting when there's an opportunity to put it on the agenda first. The board should not make any comments to the speaker or begin to discuss the subject matter, and of course, no action whatsoever should be taken at the meeting during which the topic is initially raised. If it's not on the agenda, you shouldn't be talking about it. Here's our final library scenario, electronic meetings. Even during non-pandemic times, many libraries have trustees who are snowbirds or have other legitimate reasons for being unable to attend a meeting in person. And so we have libraries wondering about the legalities of having electronic meetings.
Section 21.8 addresses open electronic meetings. Subsection 1 says, a governmental body may conduct a meeting by electronic means only in circumstances where such a meeting in person is impossible or impractical. And the governmental body must provide public access to the conversation. This means that a speakerphone where the caller can hear all the attendees and the attendees can all likewise hear the caller is an acceptable form of an electronic meeting, as are Skype or Zoom type programs. Access to electronic meetings must be made available to the public, for instance, by publishing a phone number or meeting room link on the agenda and on the library's website or Facebook page. During the COVID crisis, the governor did temporarily amend this section of the code to eliminate the requirement of a physical meeting location. However, under normal conditions, all electronic meetings must also have physical meeting locations where members of the public can observe the meeting if they choose not to join it electronically.
Where boards need to be careful is with email. Email is not an acceptable form of an electronic meeting because there's no way the public can easily access your email discussions being transmitted among trustees. It is advised by the former director of Iowa Public Information Board that when sending an email to all members of the board, do so with a BCC, blind carbon copy function, to prevent anyone from inadvertently replying to all, and thereby creating an email discussion that could possibly lead to a decision made via email, which would mean your board just conducted an illegal meeting.
As we close this module, we want to again remind you of the valuable resource which is the Iowa Public Information Board. This state agency exists to answer questions about compliance with our open meetings and open records laws and to investigate complaints that specific governmental bodies are not compliant with chapters 21 and 22.
We encourage you to view our more in-depth presentation about open meetings, open records, in which we delve into additional scenarios and offer additional guidance as to the effects of these laws on library board meetings and with respect to the library's records. This concludes our module about open meetings, open records.